Hello, good evening, everybody. I'm just trying to update my social media platforms. So then we'll just wait for everybody to join. Just like our normal Facebook Live event. Can you just give me a feedback if I sound okay? This will not be a long conversation. It will just be giving updates on the H4 work visas, just to clarify some issues. Okay, so we just wait for others to join. Okay, thank you for giving me the feedback. So this will actually be of interest to people who are currently on H4, H1 visa or planning to come to the United States on an H1 visa or kung nag-J1 kayo, visa, and then planning to transition towards the H visa. So I think this will be a good conversation for you. Hello, Sir Jerry. Good morning po. Ay, good evening na pala. So how's California, boss? Okay, so yeah, just give me 2 minutes. I just have to update my Facebook, my social media platforms. Okay, so good evening everyone here in the East Coast in the United States of America. Magandang umaga po sa Pilipinas. This event will just be a very short update on the H1 or H1 H4 visa. So we'll start with preliminary concepts here. So the topic for today are H4 visa holders allowed to work? That's a question that we're gonna ask today. Okay. So then, if you have questions, just write them down in the comments section below. I'll try to answer them as we go along with our Facebook Live. Disclaimer lang muna, joining this event or being part of the conversation doesn't mean or doesn't create lawyer-attorney relationship, but I'll try to answer your questions in a general term. But again, don't take it as a specific advice to your case. If you would want to discuss your case in details, you can actually send a message to iDream America 2 or in my messenger, then I'll try to connect it to my staff so they could actually schedule an appointment with you. So again, without much ado, we'll start with our topic for today. So let's start with the general concept. When we actually talk about H1 visa, this is actually called the specialty occupation visa. It's a specialty occupation because it requires at least a bachelor's degree. So kung kunwari, if you don't have a bachelor's degree and you're looking for opportunities in the United States, then unfortunately the H1 visa is not available for you. So yung mga H4 mo are H4 visa holders are actually the dependents of the H1 visa. So they cover the spouses and the unmarried minor children because pwede silang dalhin ng H1 principal beneficiary to be with them in the United States. The problem is, generally speaking, H4 dependents cannot work. That's the general rule. But because of some developments in the law or the regulations, some of the sectors of the H4 visa holders are given the privilege to be able to work. So when we actually talk about AAD, kasi maraming beses mo siyang maririnig, ang ibig sabihin nun, this is the Employment Authorization Document. It is not really a document though because it's actually in the form of a card. It's a plastic card just like the green card, but again, it's called the AAD for short. So nasabi ko na generally speaking, they are not allowed to work. So when you are actually planning to come to the United States on an H1 visa and you are planning to bring your spouse and your children, then make sure that you have to analyze the financial component of you migrating to the United States kasi ikaw talaga yung breadwinner pagdating dito. No? So your H4 spouse will be a dependent, sorry, just supporting you in all other aspects in your life as a worker in the United States. Your children can go attend school or kung anumang events, activities na gusto nilang gawin. They can do that, but they cannot work. So ikaw talaga yung primary breadwinner. So you have to make a primary consideration as to the cost of living, sweldo mo, and all other expenses that you need to bear once you are actually in the United States. However, the law provides exception to the rule, and part of that is um, pwedeng mag-apply ang H4 spouse if yung H1 dependent, and I'm talking to because we have a large following for Filipino teachers coming to the United States on H1. So in those cases, the teachers H1, and I just want to actually clarify no na yung H1 hindi lang limited to the teachers. So again, just like what I've said, any profession that requires a bachelor's degree could basically fall into the H1B visa. So again, general rule, the dependents cannot work. However, the law provides that if your H1 spouse is a principal beneficiary of an approved I-140, and we will talk about that in a bit, or has been granted H1 status beyond the 6 years. So again, no, I will go deep down into those two aspects para mas maintindihan talaga ninyo if you are actually new to the H1 conversation. So, sinasabi dito sa slide na to na wala ka, hindi pa pala naka-share yung slide ko. Just give me a second. I thought I was sharing my slide. So here's my slide here. So employment authorization are actually given to the H4 spouse dependents if the H1 visa holder is a principal beneficiary of an approved I-140 or has been granted H1 status beyond the 6 years. So let's understand more of that. So the general rule, pag H1 visa holder ka, you could stay in that visa category maximum of 6 years. So normally it is given in 3-year initial visa validity, and then pagdating mo rito, it will be extended to another 3 years or then another 1 year. Okay? But here comes the company policies na hindi naman kailangan matapos yung 6 years mo if they are actually interested to transition from your H1 visa to a green card or permanent residency, then they can actually do that. So if the company was impressed with your performance and they decided to give you a longer platform to be able to work in the United States, then pwede ka nilang offeran ng permanent residency or green card. So hindi mo kailangang tapusin yung 6 years mo. But there are just cases where magastos kasi yung H1, then the employer's policy would actually say, we would want to maximize the H visa, and then we will transition them to the green card. So ito yung second portion mo na pag halimbawa because of the long processing of visa or the delays in whatever aspect that affects the processing of your H1 visa or green card application, then the rule allows H1 visa holders to stay in the United States still on the H1 visa category before the 6-year period. So ano ibig sabihin na pwede pala mag-apply ang asawa ko pag I have I approve I-140. So an approved I-140 is actually an immigrant petition. So ito yung sinasabi ko na if your employer is supportive of you transitioning from the non-immigrant H visa to a permanent residency green card, then pwede nilang i-file yung I-140 mo. And of course, we're gonna talk about labor certification in the next slide. But ito yung form na ginagamit ng employer to apply for your immigrant visa. So, ibig sabihin, you're already in the process of becoming a green card or a permanent resident. Or kung kunwari, halimbawa, sinisimulan pa lang ng employer mo yung application mo or process mo towards getting your green card and you're already beyond the 6-year maximum duration of your visa, you're still allowed to apply for a work permit and you'll still be able to extend your stay in the US on the H1 if you fall into some of the eligibility requirements. So, magbasa muna ako ng mga questions dito before I'll proceed kasi medyo konti lang naman yung slides ko, no? So, I'm gonna spend time on answering questions. So, if you have more questions, again, I didn't intend this live to be long kasi nga very short lang naman ang topic natin. So, we have here a question about good morning from the Philippines. Pwede po ba shout out to your employees? Okay. Ma'am, kung sino to, ma'am or sir, naka-Facebook user ka kasi, say, hey, Thea, Tracy, and Shay, shout out daw, sabi ng ating viewer dito. Okay, thank you po. Carlo, what should I apply if I am in Thailand, currently teaching here? So, again, this is a question that pertains to most teachers, no? So, and I've been very vocal about my support on the H1B visa. I've been very supportive of yung mga teachers who are subject to the 212E. And again, the J1 visa conversation will be covered in a separate live event. It's been a long time since I've talked about the J1 visa, but the J1 visa is an exchange visitor visa, so it's not really an employment visa. But through the agreement between the Philippines and the United States, some of the professionals, I mean, the professions in the Philippines are able to come on a J1 visa, an exchange visitor, but most of them are subject to the 212E. So, ibig sabihin nun, uuwi sila for 2 years before they can come back. So, dahil dyan, they will be spending time here for 5 years, and regardless of whether their employer love their performance or how good they are in terms of their profession, they have to go home because, again, they cannot apply for the green card or they cannot change their status from J to an H visa or any other type of visa. So to answer Carlos' question though, sir, if you have an offer, job offer from a school because you're a teacher offering you an H or a J1 visa, I would recommend that you convince them that you get an H visa. Kasi pag mag J1 visa ka, there is a bigger likelihood that you will go home to the Philippines or back in Thailand for 2 years before you can transition to another visa type. Sir Jerry, again, thank you for watching, sir. What visa should I apply if I'm in Thailand? So again, apply for the H if you have an offer. Sir Julieto, attorney, my kids had their EAD card, but wala pa man lagi sila SSN card. That was since January pa waiting, pero walang dumating. So, boss, ang tanong dito, pumunta na ba kayo sa Social Security Admin Office? Kasi unlike green card applications, kung matagal kasi, kung diba natanggap mo na yung work permit mo, and then the Social Security number has not been sent to you yet, you could basically go to the Social Security Admin and then show them your work permit and apply for your Social Security number. Just like for the information of everybody, it is a crime to apply for more than one social security number. So once you go to the social admin office, make sure that you explain to them that you already have your work permit, but you haven't received your social security number or card yet. But you can basically, don't wait for long. Pwede mo naman puntahan ang social security admin. From Griselda, can a couple both work as H1B visa holder if they are teachers and will get H1B offer? Yes. So, hindi kailangan na maging dependent. If you are eligible to receive H1B and you will be offered ideally for the same school, as you can be both H1B visa holders coming to the United States. Lovelyn, I want to learn a lot on this, attorney. I am an aspiring teacher to teach in the US and hopefully an H1B for some reason. So yeah, ako personally, if you have the option of getting an H1B offer, and if the employer is having the conversation with you and they are not familiar with the H visa, I would recommend you can actually give our information to them. Part of our advocacy or what we are doing here in the United States is educating some school districts about the other visa types. Most school districts are aware of the J1 visa, but they are not so familiar with the H visa. So choose the H over the J1 visa then. Okay, I'll proceed to the next slide. Uh, so pag within the 6 years ka, again, you are allowed to work, but not your dependents, except if they fall into some of the exceptions that we're gonna talk about. One of them is that if you are already beyond your 6th year, your spouse can apply for a work permit if your employer already had filed the labor certification. The labor certification is required when an U.S. employer is planning to file an immigrant petition for a foreign worker. It doesn't matter if that foreign worker is already in the United States or outside the United States as a permanent resident. So all other professions are required to get a labor certification from the Department of Labor to prove that there is no U.S. citizen or permanent residency willing and able to perform the job being offered. So in the case of teachers, and I will talk about the teachers because there's a lot of followers on our social media platforms. So pwede kang pumasok on an H visa and alam natin na maximum 6 years yon. But because the employers are very impressed with your performance, they can even offer you a route to the green card on your second year or 6 months or whatever, unless their policy actually limits them to make that change of the visa categories. But they can if they want to. So, except for nurses and physical therapists, we need U.S. employers needs to file the labor certification. Again, this is a process that is being applied with the Department of Labor para hindi ma-compromise yung mga US workers, no? And also to protect the foreign workers na if there will be benefits to be given to them, it should be at par with the benefits that the US employers are giving to their US workers. So it's basically a protection for both, either the foreign workers and the US workers in general. So once the Department of Labor issues that labor certification, then that US employer is now can now bring in foreign workers on permanent residency. So again, hindi kailangan dumaan ka sa H before ka pupunta sa green card. Pwedeng dumiretso ka sa green card just like what's happening with the nurses, no? May mga teachers din na hindi nadadaan sa J or H because they already have that conversation with the employer. Pwede na silang ino-offeran ng green card agad. But that process is called the labor certification. Ang hindi lang dumadaan dyan are nurses and physical therapists. So, yung I-140 naman, once the labor certification is approved, then that's the next step that the U.S. employer need to do. They're gonna file the formal immigrant petition with USCIS, the U.S. Citizenship and Immigration Services. There are two types of processing that. They can actually do the normal processing, which could take about 9 months, or they can do the premium processing, in which case the government commit to make a decision within 15 business days. So most of our teachers who are actually processed on H1 visa or immigrant visa are processed on premium processing. So para mas mabilis. So again, tanungin ko lang dito ngayon, mga tanong dito. Michelle, attorney, para sa dependents po, may I ask, may expiration po ba ang follow to join? Follow to join, generally speaking, ma'am, is dapat 1 year lang. But with the pandemic kasi, for as long as the relationship exists, the embassy were still able to to process the follow to join. Juliet, hello again. Regarding sa SSN ng mga anak ko, we did try to ask the nearest SSA, pero sabi nila, hindi raw allowed sila to give it to my kids since they are J2. It's USIS daw po. Ano po talaga, attorney? Please ask. So, then again, ma'am, no, there is an agreement last year that USCIS and Social Security Admin actually had an agreement that when you actually apply for a work permit, together in that application, hinihingi mo yung Social Security number, even for the kids. So in the cases that we handle, ang justification kasi namin doon, while those children are not intentionally applying for the work permit to be able to work, but they just need the SSN for insurance coverage or kung ano mang other applications that require SSN. I think to answer your question, again, I don't know how you filed your application because in the form, kailangan mo talagang i-check yung box if you plan to apply for the Social Security number or card. It's not mandatory. It's up to the applicant if they're gonna click that, check that box. If you fail to do that, then wala kang aasahan na Social Security number. And I think you just have to explain to the SS admin kung anong nangyari sa application mo. If not, call USCIS, ma'am, what's going on with your Social Security number and ask them for guidance kung kayo lang nag-process ng work permit niya. Hello, Tita Marie. Thank you for tuning in. Salamat po. I've been watching your Facebook post. Okay. Let me know if you're back in the US or if you are in New York. I definitely would want to see you. Okay, so let's go ahead with the next slides. So ito yung pinag-usapan natin on the H visa, maximum of 6 years compared to the J1 visa that actually has 5 years maximum validity. And just like the J1 visa, you will be given initial 3 years, but for professions that require licensure, so in particular the teachers, no, the state, most of the state requires you to have a state teaching license, and then but before you can get a full teaching license, you have to have a Social Security number. So when we file H1Bs for the teachers, if they don't have Social Security number and the state requires them, then you will only be given initial 1 year. Then you arrive in the United States. you will apply for your socials, and then you work on your full teaching license within 1 year before yung school mag-renew for another 3 years. So, but for the other profession, the principle applies. So, it is just depending kung yung profession mo ba is requiring a state license. So, yun yung duration, no? So, may advantage pa rin yung age mo kasi 6 years siya compared to the J1 visa. So, then, ito na ngayon, ang one of the instances where your spouse could apply for the work permit if you are already on the 6th year. So, when I arrived in the United States, though, I am on the L1 visa. This is the multinational executive, and it was the recession at the time because the L and the H somehow share the same fundamentals, right? So, after my 4th month arriving in the United States, I was able to convince my employer to start processing my green card application. So, the same manner applies if you are on an H visa and if your employer is impressed with your performance, you can have the conversation if it's okay for you, for them to start your green card application. So, pag beyond 6 years ka na, normally the rule is you have to go back or you have to get out of the United States and stay out of the US for 1 year before you can come back on the H visa. Pero kung ang employer mo naman is very impressed with your performance, then why wait for the 6th year before mag-start ng green card mo? So we normally encourage our clients, school district or employers na to start their green card application on the 3rd or in the 4th year para to make sure na hindi na mawala ng status. But just for purposes of conversation, especially the Indian nationals, right? If you're gonna file for green card application for them, the waiting period is 10 years based on the visa bulletin today. Fortunately for the Filipinos though, we don't have to wait for that. Currently, the visa bulletins are current. So, ibig sabihin, once you have an approved labor certification, you can file your green card anytime. But let's just talk about the scenario where you are already in your 6th year, you are supposed to be going home, but because your employer already started the labor certification and it has been pending for 365 days and it has not been decided yet, then the rules allow the H1B to renew in 1 year increment at dahil ang dependents mo, depende rin doon sa validity ng H1 ng primary visa holder, which is the H1 visa, then pwede silang mag-renew, mag-apply ng work permit in 1 year increments. So habang hindi na-approve yung labor certification and they are already beyond the 6th year, the H1B mo na asawa, pwede niya mag-renew ng 1 year, and then since you are an H4 dependent, you can now apply for the work permit. Then 1 year lang din yung renewal nyo. However, if approved na yung labor certification, so again, the labor certification is a document is issued by the Department of Labor na, yeah, walang applicants on the job offered in the United States, then you can hire now foreign workers. If it's been pending for 180 days, then again, the H4 dependent can apply for their work permit. So again, if the I-140 was filed at least 365 days from today, kasi gusto mo mag-apply ngayon, then your spouse can apply for a work permit. There is also another avenue where your spouse can apply for the work permit even if they are not on the H or even if they are on H visa or other visa category. So some of these examples are even if you are on a J1 visa and you are not subject to the 212E and you are married to a US citizen, then they can apply for the green card concurrently with the work permit. And generally speaking, the work permit are issued 3 to 4 months from filing or 5 months from filing. Then you could basically work. Okay? So stop na tayo ngayon. Tingin tayo dito. See you soon, Tita Marie. Clyde, hello attorney, how soon po ba pwede ka i-petition ng employer for green card after ma-approve ka ng H1B? So again, boss, no, ito yung sinasabi ko kanina, that there is really no strict rule with regards to the employer starting your green card application. So somehow this is where the company policy comes in. No? So there are school districts na ang policy nila is you have to complete at least your 3 years H1B before they can start the conversation of filing your green card. Meron din kami mga school districts where they only need 1 year of your performance to actually know how well you perform or you do your work. And if they're happy with your performance, they're willing to start your green card application. Okay. Hello, Miss RJ. Yeah, ma'am, siguro next week or probably the week after, I will be in Florida, by the way, next week for a business event. So, yeah, I will be talking about national interest waivers or exceptional, um, extraordinary ability, especially in the field of the teachers. I'll promise you that. No? Kasi marami ding mga inquiries doon. Okay, going back here, and again, I think I'm already on the last three slides of my presentation. Last year, ang daming inquiries nito ay, oh, sorry, in 2021, ang daming tumatawag sa office namin because then again, no, most of the followers namin are teachers, and of course, when their J1 visa is about to end, and ang understanding kasi natin, a J1 visa is also an it's not really an employment visa because again it's an exchange visitor visa, but it still has given them the privilege of being able to work in the United States. So when their visa is about to end, of course they are looking for ways na ma-extend yung J1 visa nila ngayon. And they heard about the automatic 180-day automatic extension. Unfortunately, that doesn't apply to the J1 visa. It only applies to the L and to the H visa. So what it says is for as long as kung halimbawa yung work permit mo dahil H4 dependent spouse ka, because the conversation now is focused on the H, and you were able to file your application before your current work permit has expired, then it will automatically be extended for another 6 months. Kasi at one point, ang sobrang tagal ng USCIS to decide on work permit applications. So again, it doesn't apply on the H on the J visa. It only applies to the L and the H visa for as long as you are able to apply on time. And at that point, they are allowing applicants to apply 6 months prior to your current card expiring. Kasi nga sa sobrang haba ng processing time, and they will automatically extend your work permit for another 6 months. And you are supposed to be in the current H4 status. So ibig sabihin, if you change from H4 and for whatever reason you change to a tourist visa or a J1 visa or any other type visa, kahit pa hindi pa expired yung work permit mo, then you can no longer apply or take advantage of the automatic extension of 6 months of your work permit. So, halimbawa, kagaya na sinasabi ko kanina na hindi lang naman kailangan na H4 ka to be able to apply for the work permit. So, if you are married to a US citizen, then you can file the work permit concurrently with your green card application. So, in that case, hindi to mag-a-apply doon. Kasi, again, this is only specific to the H4, to the H and the L visa, yung automatic. And this is actually a settlement between the United States and a class suit. In the case of Sir Hill versus Mayorkas, this is again decided in 2021. Louis Boy, uh, can I get, uh, hi attorney, can get help from the tribal council? I'm here in Village, Alaska, before my fifth year. I think I'll be doing another Facebook Live on the interested government agencies. For the longest time, the BIE, the Bureau of Indian Education, has not been supporting waivers on the J1 visa, but we are currently supporting one school district now, and the BIE seems to be very supportive of uh, the the interested government agency. And again, I think it was early this year. I actually posted a guideline like, hey, if you need help on the waivers, you have to ask your employer first to reach out to the BIE, and if they are very supportive and willing to help you out, that's when they will advise you to look for a lawyer to actually help you with the process. For J1 subject to the 20E, is there a possibility to convert to a green card? Unfortunately, no. If you are J1 subject to the 212E, you have to have at least a waiver to change from J to H or to a green card. It's very rare to transition from J1 to the green card. So normally, for teachers or any professions that are subject to the 212E, dadaan muna sila ng waiver or they have to go home and stay for the 2 years and then ipaprocess yung green card. No? So again, if you are subject to the 20E, you have to apply for a waiver, and if you cannot apply for a waiver, then you really have to go home. And that's the sad reality of a J1 visa. Nidia, can the employer file for green card while waiting for the J1 waiver concurrently? Can an employer file for a green card? It's too risky though, no? Kasi kung if you will not be approved of a waiver, the green card process could still be approved. I will not approve, but kung maunahan ka ng green card interview without the waiver approved, it will be denied. So I don't think it's the best strategy there. Hello ma'am, kumusta po? Is it possible po ba ang J1 not subject to the 212E na nauna dito sa US, then sumunod ang J2 pagpunta dito sa pero may tatak na subject to 12E or need for an opinion? So, ma'am, yung advisory opinion kasi sometimes there is a political color on that, no? So, there are times where the embassy commits errors na instead na tatakan nila yung J1 visa mo na they are subject to, but they forgot to actually mark that. No, we've seen cases like that. And then when you apply for an advisory opinion with the Department of State, they will actually come back to say even yung applicant na hindi subject to the 212E initially, lahat na sila subject to the 212E. So, but just to answer your question, need po ba ng opinion? Of course, that's the remedy, ma'am, pag mayroong discrepancy between family members. But chances are, if you're gonna apply for an advisory opinion, baka madamay pa yung isa, no? That's really something that you need to discuss with a lawyer handling your case, no? Kung what's best for you. Facebook user, I want to confirm if this statement, especially the part about not being allowed to work, is valid. H1B will be much faster than the EB3 process, plus the first two steps of the EB take multiple years and not allow you to work. Okay, klaruin ko lang ha. I want to confirm if this statement, especially the part about not being allowed to work, is valid. H1B will be much faster than the EB3 process. Yeah, H1B can be approved in 3 weeks, excluding the labor condition application. But labor condition application can be approved in 10 days. So basically, if you look into the H1B, 1 month and a half, if it's processed in premium processing, may H1B visa ka na compared to the EB3 process, which could take minimum 2 years. So talagang mahaba yung EB3 mo. Plus the first two steps of the EB3 could take multiple years. So just like what I said. So, ang ibig sabihin nun, I am not so sure if you are saying, pag kunwari H1B ako and then sinimulan na ng employer ko yung EB3 ko, can I work? Yes, if your H1B is still valid. But if your H1B is no longer valid, of course you cannot work. No? Kahit pa yung first two steps mo ng EB3 mo is still at the Department of Labor. So what are the first two steps? Una, prevailing wage. Pangalawa is yung labor certification. And that two processes alone could take minimum 2 years. So for that time being, kung wala kang visa na valid, you cannot work unless you have any other type of visa, example, H1B, na valid pa, pwede mong simulan. Kaya nga ang sinasabi namin, if your H1B has the maximum years of 6 years, on the third or the fourth year, we have that conversation with the school district to say, or your employer, why don't you start now with the green card application so that kahit hindi pa siya aabot ng 6 years, pwede na siya mag-transition to the green card. And I hope I was able to answer that question. Hello, Ma'am Annalisa. Okay, my neighbor in Canada. Thank you for watching. Okay, my last two slides. So ito yung 180 days. I hope I was able to clarify that. That doesn't apply to the J1 visa. It only applies to the H and the L. Okay, ito yung nag-steer ng a lot of nag-steer ng conversation, no? When the federal court in the District of Columbia, DC, basically actually issued a statement confirming, so affirming that the Department of State has the authority to grant work permit. So, ang impression kasi when you actually hear the news that, oh, all H4 visas now, visa holders now can work, no? And as much as that is the message that I wanna say, but I just have to clarify that. So let's talk about the background of this case. Now, so this case actually is case filed by Save Jobs USA. Okay? So again, balik tayo dun sa premise na ano ba ang work permit H4? Because the general rule, if you are the spouse or the dependent of an H1B visa holder, you cannot work. But again, just like what we've discussed in the last few slides, you could apply for a work permit if you fall into one of those exceptions. But then, Save Jobs USA, this is an organization that protects US workers. So kung iisipin mo, if yung H1B mo na teacher ang allowed to work, and then here comes your US citizen workers or permanent resident workers who may not have the same skills and specialization that you have, may not be able to actually get that job. So this actually pertains especially in the California area we're in ang daming tech industries involving there, right? Especially with the Indian nationalities where they have to wait for 10 years before their green card can be approved. So anong gagawin mo ngayon? Kung H1 ka or H4 ka, you only have a limited number of 6 years and then you have to go out of the country because your green card will take 10 years to be approved. Then anong gagawin mo in the 4 years in between? And it also resulted to instability with the employers kasi ibig sabihin nun, every 6 months, magpapalit sila ng employer. So, buti na lang that with the rule na pinag-usapan natin, the H1B visa holder are allowed to apply for increment of 1 year kung meron na silang pending I-140 or meron na silang approved or pending labor certification. So, yun yung purpose ng Save Jobs USA. They basically sue the Department of the Department of State to say, oy, hindi kayo pwedeng mag-issue ng work permit to these dependents kasi dapat yung H1 lang yung bibigyan nyo. But if you actually look into the other non-immigrant visa categories, if you are a dependent of a student visa holder, right? So, halimbawa, MBA graduate ka. So, then you have the F1 and then you were able to actually work permit. If you could actually argue that, hey, there is a financial hardship, then they could basically apply for the work permit, no? And the other visa types, could also apply, the L2 for some situations or exceptions could also apply for the work permit. So what they are actually saying that walang karapatan daw si Department of State mag-issue ng visa. Na yun yung argument ng Save Jobs. But then the federal court in District of Columbia actually says na no, I don't agree with you. The Department of State has the authority to issue those employment visa. So it's basically good news for the non-immigrant H4 spouses because it actually protected their privilege of being able to work by having the ability to apply for the work permit pag nagpo-fall sila doon sa criteria na pinag-usapan natin. So I really hope that I clarified that rule because that was actually the recent update arising from the decision of the federal court in the District of Columbia. So hindi siya bagong rule. No, but during the initial stage of Biden presidency, there were actually efforts to basically grant. And me personally, though, I really believe that yung H4 spouses or dependents who are in their working age should be able to work, right? Kasi kung J2 nga, the dependents of the J1 are allowed to work, knowing the high cost of living in the United States, why not the H4? But of course, I am not the decision maker of the policies. But we are just hoping that USCIS and Congress would be able to correct that situation and allow H4 visa holders to be able to work. So that actually is my last slide. The next ones will be just summary page. If you want to follow any immigration updates, please follow me on TikTok, or I also have a YouTube channel, The Caracal TV. Again, just if you would want to have immigration updates. So before I close this live event, I just have to answer some of the pahabol questions. I want to confirm okay, I think I answered that. And then two last questions. From Ryan, while waiting for the J1 waiver, an employer will sponsor us for the green card before the expiration date of our program. Is our stay here beyond the expiration lawful? Klaruhin lang natin to ha, because when you apply, the general rule kasi, and this could be confusing. If you apply for a green card, so halimbawa, tourist visa holder ako, na, and then I am married to a US citizen, and then nawalan ako ng status, if I'll file a green card, wala na akong unlawful presence the moment na nag-file ako ng green card. And then I will start incurring unlawful presence pag na-deny yung green card application ko. There are two concepts that you need to understand. Lack of status and unlawful presence. So ano ba yung status? Yung status mo is kung ano yung visa mong ginamit nung pumasok ka sa US. So kung pumasok ako sa tourist visa, ang status ko, tourist visa holder. If pumasok ako ng J1 visa, ang status ko, J1 visa. But then, I'm allowed to stay here for 5 years. And normally, nag-e-end yon on June 30, plus 30 days grace period. So, meaning, July 30, after that date, I will incur unlawful presence. So, sa question mo, boss, if your application, green card application, has already been filed, is your stay allowed in the United States? So again, if you are able to file your green card application on time, then you are still in status and you don't incur unlawful presence. So, to answer your question, is your stay here valid? Hindi siya simple yes or no question, boss eh. No? Kasi, kung ang tagal ng process, and again, we haven't talked about if you are subject to the 212E or if you already have the waiver approved. So, if you are talking about J1A waiver in general, halimbawa, nagtatrabaho ka sa hospitality industry, and since the government also has taken steps to waive green card interviews, there's a possibility that you could be on a J1 visa and you could still be able to stay here lawfully and get that green card, no? But then again, there's a lot of factors that could affect to answer this question. So again, I don't know if you're subject to the 212E. I don't know if you are, again, other factors, if pang ilang years mo na, and so on and so forth. So I would recommend Ryan to consult with an immigration lawyer to fully discuss your case para lang mas better guided ka. Good morning. When is the perfect time to apply for the H1 if the district offer you one on the third or the fifth year? So, boss, kung you are a J1 visa holder not subject to the 212E, and I fully understand that you have contracts under between you and your J1 sponsor and between you and your employer. So, hindi siya ganun kasimpleng conversation. But I would just answer your question here. I would recommend that if you are not subject to the 212E, you have to apply for H from J1 to H while you are not renewing your J1 visa yet. Kasi kung maghihintay ka, boss, even if you're not subject to the 3 years at mag-a-apply ka ng 2-year extension mo, even if yung makukuha mong DS 2019, walang mark na you are subject to, chances are you will become subject to, which will prevent you from getting that green card. So to answer your question, if you can do the transition from J1 to H within your first 3 year, if you are not subject to, then do that at that time. Salamat, Ma'am Lovelyn. Okay, one last question for the night. And again, thank you very much for watching. Ay, hula. Tinag lang pala yung mga kaibigan niya. Again, so guys, thank you very much for thank you for watching the Facebook Live. I really hope that I was able to give a very short, quick update about H4 work permits. So again, there is really the federal court just actually affirms the rule that H4 dependents are eligible to apply for the work permit subject for provided that they actually they are eligible and complies with the minimum requirement. So if you have further questions, send me a message or send a message to iDream America 2 or to my account, and then I'll try to connect it to my staff. So again, maraming salamat. Good night here in the US, and magbandang hapon, umaga, anywhere in the world. Bye-bye.